This is Laws 11057, John Milburn. The introduction to law subject for this evening is an introduction to the REIQ contract, which hopefully you see on screen. The REIQ contract is a document which is co-produced by the REIQ and the Queensland Law Society. As part of the study of Introduction to Law, I'm keen for you to be ready to deal with basic issues that you might be confronted with in a law office from day one, as it were. So assuming, for example, that on your first day at work, you're asked by a partner of a law firm to review the REIQ contract with a view to advising a client who is looking to sign the contract, I would like to run through in a two-part session the basics associated with that contract. Now, you will see that the contract has a number of commentaries, and the first is in the heading itself. You'll see my cursor hopefully there. And throughout the document, there are a number of things which provide information which should be read carefully, and I'll refer you to. The contract is in two parts. The first is the items schedule, or the reference schedule. That runs for a few pages, and after that we have the special conditions and finally the terms of contract. The contract for residential houses and land will also be accompanied by some disclosure documentation, and I'll provide you with information about that shortly. But for the moment, let's review the reference schedule. The first thing that I want to do is draw your attention to this information at the head of the contract, which deals with GST liability. Most of you will be familiar with the fact that when you're buying or selling houses or residential land for residential purposes, there is no GST liable associated with the sale. But there can be an exception to that, and you need to be mindful of the possibility for an exemption, or exception rather. And the contract provides that there is no GST liable except for new residential property, in which case the issue of GST liability must be dealt with by way of special condition. What that means then is that there may be a special condition which would require GST to be paid on it. So be mindful of that, and be particularly wary in circumstances where the seller of the property is a commercial developer or perhaps a bank exercising power of sale. In those circumstances, there may well be a special condition which would impose a GST liability. Looking at the contract, firstly we have the agent. Now that should be, I guess, for the most part, fairly self-explanatory. We're talking about the real estate agent there. If you're acting for the seller of real estate, be careful that the agent on the contract may be different to the agent with whom your client signed an agency agreement from the outset. So if, for example, your client signed an agency agreement giving a particular agent a sole or exclusive agency for a period of, let's say, 2 months, and this contract is presented during that period of 2 months with a different agent, then unless you're careful, your client, that is the seller client, may be exposed to double commission. That is, one full set of commission to the agent nominated on the contract that you're asked to review, and in addition to that, a full commission to the agent with whom your client signed a sole or exclusive agency to sign. So just be aware of that and ask the appropriate questions. Moving down the page, the next entry is to do with the seller. And you might think that that is very basic, and that is, if you're acting for the seller of the property, the name of your client. But a couple of words of warning. The first is that the title deed may not reflect the information provided to you by your client. It may be, for example, that your client owns the property in a company or a trust, which, albeit controlled by your client, is not your client as you believe that your client to be. So do a title search, and that will ascertain with some certainty the registered proprietor, and that should be the same entry as nominated as the seller on the title. Another example where your client may not provide you with the correct information inadvertently is, for example, where there's been a death of a co-proprietor. So let's assume, for example, we have your client is an elderly person who comes to you to sell the family home, which is in the name of your client and the deceased partner. You need to make provision for allowing a transfer of the ownership from both names to the survivor, and that can take some time, and that should either be attended to before the contract is signed in the name of the surviving spouse, or alternatively some provision is made by way of special condition for the property to be transferred into the name of the surviving spouse on or before the day of settlement and to the ultimate purchaser. The seller's solicitor, that should be fairly straightforward, but there are some tricks there as well. For example, the agent may nominate a particular seller's solicitor, and the seller's solicitor who ultimately conducts the transaction may be a different solicitor. The reason I bring that to your attention is that there are some provisions in the contract which provide that valid notice can in some circumstances be given to the seller or the seller's solicitor. So if that information about the seller's solicitor is not updated, the seller or the actual solicitor acting for the seller may not be aware of a notice which was sent by the buyer or the buyer's solicitor or the agent to the seller's solicitor as nominated on the contract, a person who is not in fact acting, and that can create some difficulties. So be aware of that and try to correct it or notify the buyer or the buyer's solicitors promptly if there is a change of solicitor, either for the seller or the buyer, as the case may be. Now, moving down the contract, the next entry that I want to bring to your attention is the entry for the buyer. Again, you might think that that's extremely straightforward and can't be mucked up, but there are some things that you need to do if you're acting on behalf of a buyer in providing advice from the outset. The first is that you need to ascertain who would be or what would be the appropriate buyer in the circumstances. Let me explain. If, for example, you're engaged by, let's say, a young couple purchasing their first home, one would think in ordinary circumstances that the property would be purchased by both of them, nominated as the buyer. There's nothing wrong with that, but you may need to ask some questions. For example, if one of the parties to buy the property is about to embark on a business venture which might carry with it some risk, or has already embarked on a business venture which carries some risk, then it may be appropriate for you to raise the possibility of acquiring the property in question in the name of the non-business owner. So if, for example, the husband, let's say, is involved in a risky business, then you might suggest the possibility that the property is acquired in the name of the wife, or vice versa, of course, if the circumstances are such that that is relevant. If then the spouse who is involved in business does encounter financial difficulties leading to judgments or indeed even bankruptcy, then hopefully from their perspective the family home can be spared and not lost to creditors as a result of the failure of that business. If the financier providing funds to the buyer indicates that both parties need to be endorsed as proprietors on the contract for the loan to proceed. There might be a couple of options available to you. The first is that you could perhaps ask for the loan to be in both names, even though the property is in the name of one of the parties only. We would do that by way of third-party mortgage. If the bank won't allow that to occur and insists that both names be put on title, perhaps another thing that might be considered is a disproportionate ownership on the title. For example, it may be that the husband owns a 1% share of the property and the wife owns a 99% share of the property. They're both on the title as owners, but the exposure to creditors or the exposure in a bankruptcy would in those circumstances be limited to, hopefully, from their perspective, 1% of the value of the property overall. If your client is purchasing the property for investment purposes, then it might be appropriate to inquire as to whether the buyer should be your client, an individual, or a company controlled by the individual, or to be established for the benefit of the individual, or some sort of trust, perhaps a family trust. Those sorts of decisions and those discussions would normally take place in conjunction with your client's accountant or financial advisor, or both. It is important, I think, to resolve that issue from the outset, because if you fail to do so and you're confronted with a situation after the event where your client says that the property should in fact be in the name of a company or a trust, there is the very real risk of exposure for double stamp duty, or transaction duty as we call it these days. And that can be a substantial amount of money. So in that situation, if your client, the individual, has acquired the property for investment purposes, at first instance, your client may be up for, let's say, $30,000 in duty. If after a month your client says, no, it should be in my company name, there will be in those circumstances not only additional legal fees and mortgagee fees, but also duty fees, and guess what? It'll be another $30,000. So that is an issue which has important ramifications and needs to be sorted from the outset. One technique that had been used very often in the past was to nominate your client as the buyer and or nominee, meaning that any nominated entity of the buyer can be the buyer. Generally, that will also result in double stamp duty if there is a nominated buyer after the event. The Office of State Revenue adopts the attitude that the nominee ought to have been nominated before the contract is signed, and there are some particular special rules that need to take place or need to be followed in those circumstances. So be very aware of the appropriate entity, the correct entity to buy the property, and also be aware of and wary of the and or nominee provision, which was used very often in the past. Moving down the page, the next issue that I want to address is the issue of the land, and one might think that that's a pretty straightforward issue. We just simply nominate the address. The next issue is vacant land or built on, and as we see in this contract quite often, where there's an asterisk, there's normally an invitation for you to delete one, and you should do so. So let's assume, for example, that we're talking about the acquisition of a property which is built on. We would insert the address and we would delete the word vacant as it appears, meaning that the property is one which is improved, built on, in other words. The next issue is the issue of description, and what we mean by description is not words to the effect a delightful colonial cottage with 3 bedrooms painted white. We're not talking about that sort of description. We're talking about the legal description as it appears on the title. And when we're talking about the title, we're really talking about, generally speaking, what we call the freehold title. It can be the leasehold title, and you'll see below there's a reference to the land being sold as either freehold or leasehold. And once again, you delete one. The default provision in those circumstances being freehold, which is the most common. So how do we ascertain what is the description on the freehold, if indeed we're talking freehold? Well, what you should do is, before the contract is signed, ensure there is a title search undertaken, which will show not only the name of the seller, as we talked about before, but also provide the formal legal description for the property. And that typically will take the form of a lot number on some form of plan, which will also be numbered. So it might, for example, be on Lot 1 on Survey Plan 1, 2, 3, 4, 5, 6. So that provides the legal description. Historically, the description was a reference to a volume, which is a page, in a folio. A folio in a plan book. So it would be lot something on plan something, which is volume something in a folio, which is a book. Sorry, I'm getting myself confused now. But in the pre-electronic stages or ages, we used to have books which contained a number of folios or pages, and those books, those volumes, were kept at the titles office in Brisbane. There were in fact 2 titles issued, the original, which was provided to the owner of the property, and the duplicate original, which was an exact copy, maintained in these books in the titles office. So in the old days, instead of going online to do a search, someone would physically need to go into the titles office and ask for the volume to be produced, and then go to the folio, the page, to have a look at the status of that particular title. That was very cumbersome, time-consuming, and it sometimes fraught with frustration. By that I mean that because there are 150 pages in a volume, 150 folios in that volume, it may be that the book was being borrowed so that a staff member could actually make an update on one of those documents, and you were trying to search a different page, a different volume in that same volume, only to find that the book was unavailable for searching at the time that you needed it. All of that has been overcome now by the electronic searching. The title reference is a number, and that title reference is a reference to the old-fashioned folio and volume reference as it used to be. The area is described as more or less, but be careful, because there are some entitlements in the contract to seek compensation if the area is substantially different to the area nominated in the contract. I've talked about the land being sold as freehold or leasehold. I'll then move on to the present use. Just be careful here, because if it's established that the present use is incorrect, there may also be entitlements to compensation payable from the seller to the purchaser, effectively in terms of a breach of contract. Now I'll move on to the second page and talk briefly about this concept of fixtures and chattels. Fixtures are things which are essentially part of the land and, unless excluded, to be sold as part of the property being sold. For example, a pergola or garden shed would normally be regarded as a fixture. In other words, you would expect that when you acquire that property, the garden shed or the pergola, as the case may be, will still be there after settlement. If it's intended that something which is a fixture to the property is to be taken away by the seller and is not part of the sale, there should be an endorsement in the contract to the effect that that is excluded. On the other hand, a chattel is something which, in simple terms, can be picked up and taken away easily. It's not bolted to the property, it's not part of the property per se, and the general presumption is that it doesn't form part of the sale. So to take an easy or obvious example, a motor vehicle which may have been parked in the garage at the time that the purchaser inspected the property would be regarded as a chattel, and it can be driven away from the property, and the purchaser would have no cause to argue that the car, being in the garage at the time of inspection, should still be there at the time of the sale, because it's not a fixture, it's a chattel, and there's no presumption that it should be sold as part of the transaction overall. Excuse me. If there are any chattels which are intended to be included in the sale, there should be a reference in the contract to those chattels being included as part of the purchase price. There are some grey areas, of course. For example, pictures might be affixed to the wall at the time of inspection of the property, and there may be arguments arising as to whether those pictures which were on the wall should be included as part of the purchase price or part of the purchase property at settlement or not. The answer to that would be to consider the question of whether the pictures in question were fixtures or chattels. The answer, generally speaking, is that pictures are regarded as chattels, even though they may have been temporarily affixed to the wall. The next thing that I'd like to talk to you about is title encumbrances. An encumbrance is something which has an adverse effect upon the property. Now let me give you some examples. A mortgage is an encumbrance. So if I own a property subject to a mortgage, that property is encumbered by the mortgage. Another example is an easement. If I own a property which is subject to an easement, giving an adjoining owner a right to go through that easement to access their property, then my property is encumbered by that easement. Now, a mortgage, of course, is a document which is registered on the title, and it gives to the mortgagee, typically a bank, an opportunity to sell that property in default of payment of the mortgage obligation by the owner of the property. But that encumbrance, that mortgage, is never intended to remain on title after settlement. In other words, at settlement, the buyer will either pay cash for the property, in which case the buyer would expect to obtain title free of the seller's mortgage, or the buyer will have funding through his or her own financier, meaning that he or she will have an incoming mortgagee and will have a new mortgage to reflect the existence of their loan, to effectively replace the mortgage which was on title taken out by the seller. So that mortgage, that encumbrance, is never intended to remain on title after settlement. In those circumstances, we would not make a reference to the title encumbrance, being the mortgage, in this part of the contract. And I'll just show you this wording over here on the right-hand side, if you can see it, just to zoom in a bit more, because it says here that if the property is sold free from title encumbrances, insert nil. If the property is sold subject to title encumbrances, they must be described. So what does that mean? Well, in the case of the mortgage, it means this. If we insert nil, it means that there will be no mortgage taken out by the seller as at the time of settlement. In practical terms, what that means is that at settlement, the seller will turn up, as will the seller's mortgagee, and the seller's mortgagee will hand over a release of that mortgage to the buyer or the buyer's solicitor at settlement, enabling the buyer or buyer's solicitor to lodge that release of mortgage at the same time they lodge the transfer in their favour, so that the mortgage will be released, the property will then be transferred into the name of the buyer, free of that previous mortgage. Now, here's a trick, here's a problem. If you were to insert the details of the outgoing mortgage in the title encumbrance section, then strictly speaking, the buyer is contracting to purchase the property subject to the ongoing existence of that mortgage for a certain price. In other words, the buyer agrees to pay, let's say, $400,000 for that property, subject to an existing mortgage of, let's say, $200,000 remaining on title. Essentially then, the buyer would need to raise an additional $200,000 in order to release that mortgage. The buyer had believed that he was paying $400,000 for the property free of mortgage, free of any encumbrances, but ends up, because of this error, having to pay $600,000, $400,000 to give to the seller, and an additional $200,000 to clear the mortgage. Now, I'm sure that was never intended and would need to be rectified, but to avoid any disputes, any arguments, any possible application for rectification of this mistake, what should happen is that when it comes to reference to the outgoing mortgage, there should be a reference of nil. Now, contrast that situation to the situation of an easement, a right-of-way easement in favour of an adjoining neighbour that cannot be extinguished by the seller, and the property therefore is sold subject to the existence of this encumbrance, which will remain on title even after settlement. That is exactly the type of title encumbrance that should be inserted in the contract to ensure that it is clear that the buyer is purchasing the property subject to the encumbrance, purchasing the property warts and all, as it were. That encumbrance will remain, and therefore it should be inserted on the contract when the contract is drafted. I'll just move now to the final topic that I want to address tonight, and that is in relation to tenancies. The same principle about encumbrances being noted on title applies when dealing with the issue of tenancies. If at the time the contract is signed, there is a tenant in occupation subject to an ongoing tenancy agreement, then at law that tenant would have the right to remain in occupation for the duration of that tenancy agreement, even if the property is transferred from one party to another. To ensure that the purchaser is aware of that tenancy agreement, is aware that the acquisition is being made subject to the encumbrance of the tenancy, then the existence of that tenancy agreement and the basic terms of the tenancy agreement should be inserted in the contract. If, however, the agreement between the buyer and the seller of the property is that there should be no tenancy in existence at the time of sale, in other words, there should be vacant possession at the time of settlement, then we should insert tenancies nil. But a word of warning, if you do that, it is incumbent upon the seller to somehow make an arrangement with the tenant to ensure that the tenant does in fact vacate at the time of settlement. If that doesn't occur and the tenant remains in occupation, the seller is unable to provide vacant possession and in those circumstances does expose him or herself to a potential breach of contract claim where the purchaser is expecting vacant possession. I will just leave you with this final anecdote. This actually occurred to me in my very first conveyance, and it was to do with a situation where my client purchased a residential house. The residential house in question was inspected by my client, of course, at the time of contract, as one might expect. And at the time of inspection, the purchaser noticed that there was a very large caravan of some quality and some value left in the backyard. There was no reference in the contract to that caravan being an included chattel. So therefore, the presumption was that the caravan would not form part of the contract and would be removed by the seller and was not part of the what was being sold to the purchaser. The problem from the seller's perspective was this. The seller vacated the home and took everything before the day of settlement except the caravan. As we found out later, the intention of the seller was to come back the day after settlement to collect that caravan and take it away. My client, the purchaser, in conducting a pre-settlement search of the property, contacted me about an hour before settlement and said that the caravan was still in the backyard, and what is the legal position if that caravan remains in the backyard at the time of settlement. My initial advice was that that's not that the caravan is a chattel. It's not an included chattel, and therefore it remains the property of the seller, and the seller can collect that afterwards. But I did say I would check the contract and I'd run it by one of the partners in the firm. Before seeing the partner, I did check the contract and I came across a clause which deals with the issue of abandonment. And that clause in simple terms said that any chattels which are left on the property as at the time of settlement are deemed to be abandoned by the seller. I then checked with the partner, and following checking the contract and conferring with the partner, I went back to the client and said that notwithstanding my earlier advice, it did appear that the purchaser would be able to lay claim to ownership of that chattel because of the abandonment clause, given that the chattel was abandoned, left there at the time of settlement. My client, acting upon that advice, did settle, and then that afternoon did remove the caravan, took it to a location where it could be sold by a dealer who was a relative. The seller, of course, was extremely disappointed to find that the caravan was gone, and there was a considerable amount of correspondence and dispute between the solicitors after the event. The end result, however, was that as there had been no prior arrangements made to retain ownership of that caravan, if it was left on the property at settlement, that the caravan was in fact essentially deemed abandoned, and my client gained that windfall. Now, that may have been reversed if the matter had gone to court, but it didn't, and my client successfully relied upon the abandonment clause to obtain that windfall of the caravan to the detriment of the seller in that circumstance. Now, the reason I leave you with that anecdote is twofold. Firstly, to highlight that what may appear to be the position on the face of the contract can sometimes be reversed by a clause in the contract or by legislation or by case law. And secondly, to highlight that conveyancing is not always the easy legal transaction or legal practice, part of legal practice, which is regarded by people as relatively easy. I have a great deal of respect for conveyancers, and I certainly don't subscribe to the theory that conveyancing is an easy part of legal practice. Some people like to think of, lay people think of conveyancing as money for jam, and in my view it's far from it. There's a lot of work and it's detailed, and I think conveyancers work very hard under pressure. So if you're supporting a conveyancer as a lawyer, have a lot of respect for the work that they do. It's not easy work, and there are a lot of pitfalls. So my advice to you is read the contract carefully, read the side notes and the footnotes and the warning statements very carefully, because they do have particular ramifications, and read the contract very carefully. That will do for tonight's session. We'll continue with a further discussion of an introduction to the Real Estate Institute contract next week. Thank you very much.